The International Covenant on Civil and Political Rights, Article 16. Everyone shall have the right, no obligation, to recognition everywhere as a person before the law. The Universal Declaration of Human Rights and Freedoms, Article 6. Everyone has the right to recognition everywhere as a person before the law. The Universal Declaration of Human Rights and Freedoms, Article 6, and the International Covenant on Civil and Political Rights, Article 16. It states that everyone has the right to take recognition as a person before the law. Everyone is granted that right. Now, as a state party, Canada, to these covenants and these declarations, have an obligation and a liability to express this article of law within domestic law. So when they were writing up domestic law here in Canada, because they were bound to the international charters, they had the obligation within the laws that they were constructing to express this article of law, which says that everyone has the right to enter into interjuridical personality, but no obligation. So therefore, if we look into law, we should find then this article of law expressed within the domestic law. So let's take a look at the Criminal Code of Canada. When you look in the Criminal Code of Canada, you're going to find words such as, or expressions such as, claim of right, lawful excuse, exemption, exception, proviso, excuse, and qualification. Now these are all terms and designations that are dealing with exactly that article of international law that speaks about the fact that everyone has the right to enter into recognition as a juridical personality, but no obligation. And in expressing your right not to enter into the person, not to enter into that juridical personality, you come to terms such as claim of right, lawful excuse, an exemption, an exception, a proviso, an excuse, or a qualification. In the Criminal Code of Canada, when anyone wants to lay a charge against someone else, whether it's a police officer wants to lay a charge against a human being under the form of a person, it's called an information. They have to lay an information. So an information is to be laid. What that is, it's a sworn documentation under oath stating that a person has committed an offense under the Criminal Code of Canada. So if you're ever called to court under the Criminal Code of Canada, you're being called because someone has laid an information, and a justice of the peace, a judge, has received it and has accepted it and wants to hear the case. So someone lays an information against a person. That's how an offense is created under the Criminal Code of Canada. In the Criminal Code of Canada, if you broke a law, if you break the law, which can be a statute, a regulation, enactment, or the criminal code itself, an information is laid against you. And that means that you did not obey the law. The enactment said you should do such and such. The enactment said that a person should act such and such way and had to follow such and such rules. And you did not follow such and such rules. Therefore, they charge your person under an information stating that you didn't follow the rules of the enactments. You did not obey the law. That's how it works with an information. Now look what the Criminal Code says in Article 15. Criminal Code of Canada, Article 15. Obedience to de facto law. No person shall be convicted of an offense in respect of an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power, in and over the place where the act or omission occurs. Article 15 of the Criminal Code of Canada states that no person shall be convicted of an offense for following the enactments, regulations, or statutes that have been given force of law, or no person shall be convicted for an offense for not following. It's called an omission, not following the enactments, the regulations, or the laws that are been given force here in Canada. So no person shall be convicted for an offense. And it talks about that these laws are enforced by de facto powers. Now how can a person not be convicted of an offense when that's what they're doing all the time? For example, if you go and you break one of the rules and regulations that are against a person, they will charge you with an information, bring you before the judge, and they will convict you of an offense as a person. But yet here, Article 15 says that no person shall be convicted of an offense. It doesn't say everyone will not be convicted of an offense. It qualifies it. It says no person. And there's a reason. Because the enactments and the rules and the laws that are being used against persons are being used, if you will say, without your consent. Without you understanding what's going on, thereby without you giving your consent. So, and these rules and these regulations that are used against a person are not common law. If you understand, they don't come from the basis of common law. That's why it's not stating everyone here. So, no person shall be convicted of an offense. Well, how does no person get convicted of an offense? How does he shake off the offense? How does he shake off being convicted for not obeying or not following the laws? For example, a man decides to go and fish, to catch fish to eat. And he did not get a permit. He did not have this right or privilege conferred upon him from Her Majesty as a person. He just chose to fish as a man without a permit. And lo and behold, along comes a policy enforcer under the guise or agency of forest ranger, and now asks to see the fishing permit or license. And that permit or license cannot be produced, and therefore the policy enforcer, not understanding the laws and regulations or what's actually transpiring here in Canada, because the State Party Canada failed in its duties to educate that policy enforcer of the rights and freedoms that are available to human beings here in Canada, that policy enforcer will try to charge you under an enactment or regulation saying that you did not follow. You were not following the enactment because you did not have a permit. And therefore you will be charged. Whether it will be a fine or if they call you into court before a judge, you're going to be charged. But here the code says that no person shall be convicted of that offense. But yet he just charged you with the offense. So how does the person, the human being who has a person attached to it, how does that person shake off the offense? Criminal Code of Canada, Article 126, disobeying a statute. Everyone who, without lawful excuse, contravenes an act of Parliament by willfully doing anything that it forbids, or by willfully omitting to do anything that it requires to be done, is, unless a punishment is expressly provided by law, guilty of an indictable offense and liable to an imprisonment for a term not exceeding 2 years. Criminal Code of Canada, Article 126, it states this: everyone, notice that terminology and designation now, it says everyone who, without lawful excuse, another terminology, contravenes an act, statute, or enactment, is guilty of an indictable offense. So everyone who breaks now, who doesn't follow an enactment, a rule, or a regulation, and cannot produce a lawful excuse, is guilty of an indictable offense, and will be found guilty of an indictable offense. Now we use that fishing as an example. A man is fishing, but in their laws, if you're fishing as a person that's been granted a right or privilege. Now, you're not an everyone, because you're not a human being there. You're a person. Now, when the forestry ranger comes by and charges you with breaking an enactment, a regulation for not having a permit, he's charging your person. Your person is being charged, not your human being. Nevertheless, because they've charged your person, who you associate that name with, and that is you the human being now, the everyone, including the human being, is forced now to deal with these charges. Is forced now. Now when you come to 126 of the Criminal Code, and it says, everyone who, without lawful excuse, contravenes an act or statute or enactment. So now you, as everyone, the human being, begin to produce your lawful excuse against why your person, or the charges against your person, should not follow through. Because at that point, when you were fishing, you made that distinction that I'm there as a man, a human being, not as a legal person. Nevertheless, the agent, who was not taught the distinctions in law and was taught fundamental rights and freedoms as the obligation was, proceeded to charge your person. And your person had to face those charges. But Article 15 said that no person in the Criminal Code shall be convicted of an offense for obeying or failing to obey the laws that are enforced by the de facto powers. But now you see the expression of it, where everyone, the human being, produces a lawful excuse, thereby the charges are removed, and the human being, but also the person, the name that is attached to you, the charges are removed also from that person. So therefore Article 15 is being fulfilled, the fact that no person can be charged. But when it comes down to expressing that article of law, of no person being charged, it's up to you, the human being, to provide the lawful excuse, the exemption, or proviso. Remember, we were talking about the Universal Declaration of Human Rights, Article 6, and the International Covenant on Civil and Political Rights, Article 16, and where it states that everyone has the right to recognition as a person. So the human being who is free is out there fishing and gets charged as a person. As a person. Now the human being, under Article 126 of the Criminal Code, produces a lawful excuse as to why he should not be charged through the person for those charges, thereby expressing everyone has the right to recognition as a person before the law. Because your lawful excuse in that situation will be your claim of right. And your claim of right is an expression of who you are, what you understand, and what designation you have decided to operate here in Canada. Now, in Article 794 of the Criminal Code of Canada, it talks about what happens when someone lays an information against a person, or when someone lays an information in the court. The Criminal Code of Canada, Article 794. No exception, exemption, proviso, excuse, or qualification prescribed by law is required to be set out or negatived, as the case may be, in an information. The burden of proving exception. The burden of proving that an exception, exemption, proviso, excuse, or qualification prescribed by law operates in favor of the defendant is on the defendant, and that the prosecutor is not required, except by way of rebuttal, to prove that the exception, exemption, proviso, excuse, or qualification does not operate in favor of the defendant, whether or not it is set out in the information. In the Criminal Code, Article 794, it talks about when an information is laid that no excuse, proviso, exemption will be mentioned. Whoever lays that information against your person is not under obligation to mention that there is an excuse that can be produced, a lawful excuse for these charges not to stick to you. That's what the code says. It's ridiculous, but nevertheless. Now, it is up to the defendant to prove the excuse or exemption. That's what 794 says. Now notice that they term or designate the one who's going to use the excuse or the exemption as a defendant. And they don't term it as a person anymore. They term it as defendant. But it says that it is up to the defendant to prove the excuse or exemption is in operation on his or her behalf. And that's where Article 126 plays in with 794. Because 126 says everyone can't be charged if they produce a lawful excuse. And here it says that it's up to the defendant to prove that there is such a thing as a lawful excuse or an exemption against those charges. And if they've charged your person, the person in any code where the law applies to a person, you can produce an excuse or an exemption, a lawful excuse, through a claim of right. If you're charged under common law, if you're charged for things such as thievery or murder or anything that relates to common law, harming your neighbor, bearing false witness, when you strip the code away, you're going to see that it's not a person anymore. So the defendant must prove the excuse or exemption is in operation on his behalf. So the human being goes there and says, I was fishing as a human being and I am free. You charge me as a person for not having a permit, not having paid for the right or privilege as a person to fish. However, as a human being, I'm under no obligation to enter into recognition as a legal person, thereby obligating myself to fulfill this right or privilege by paying for it. So you produce your lawful excuse. Now again, Criminal Code of Canada, definition section. Property includes real and personal property of every description, and deeds and instruments relating to or evidencing the title or right to property. Criminal Code of Canada, definition section. Public stores. Public stores includes any personal property that is under the care, supervision, administration, or control of a public department, or of any person in the service of a public department. Criminal Code of Canada, Article 39, Defense with claim of right. Everyone who is in peaceable possession of a personal property under a claim of right, and everyone acting under his authority, is protected from criminal responsibility for defending that possession, even against a person entitled by law to possession of it, if he uses no more force than necessary. So Article 37 in the 39, in the Criminal Code of Canada states that everyone who is in peaceable possession of personal property under a claim of right. Now, personal property in the Criminal Code of Canada, we know that this is being held in public stores. Personal property is any property that is being held in public stores. Now, all personal property in public stores, which, now look at the qualification, which is administrated under the care of or control of a public body. So all your personal property is in a public store and is under the control and care of a public body. But if you have a claim of right, if you put a claim of right into play up here, then the code says that you have the right to hold your personal property under a claim of right, and that if anyone tries to remove your personal property that you're holding, the qualification, under a claim of right, even if they come with a legal demand, because they're trying to claim they are administrators, or they're trying to claim that they're taking control or care of your property through a public body, that you have the right to tell them in nice terms, take a hike, because all this personal property is being held under a claim of right, and you have no right to it anymore, because as such it's no longer considered to be part of the public store. When you put a claim of right into existence, into play, you are taking out your personal property that you have worked for with your hard energy out of the public stores, and legally and lawfully out of the hands of the public body.